Hi everyone, I'm Attorney Poonam Minhas. I practice U.S. immigration law all over the United States. Today we are going to talk about various updates under President Trump's policies now that we are 5 months in after he took office. So please stay tuned just to find out about various updates either reported by my colleagues, other attorneys, or by personal experience. So one of the first updates is that interviews have now been increased. So under the Biden administration, interviews were more likely to be waived if you file a full-fledged case. And I'm not saying that waivers are not possible now. They are happening rarely. I myself have gotten maybe a couple of cases where waivers are still possible under the Trump administration. However, a lot of my colleagues and other attorneys have been reporting that not only are interviews back up and everyone has to appear for them, but some interviews where you would not expect them to be very lengthy are turning out to be lengthy. For example, the U.S. citizen child who's filing for adjustment of status for their parent ends up getting a 2-hour interview session. So it's like, what could they possibly ask? So that's happening. If you do get scheduled for an interview, work with an experienced attorney to have them by your side if you need somebody to go with you for that interview or to prepare you in advance before you go in, and make sure to have your documents reviewed. The next thing is this has been out for a while. This actually went into effect back in January where, prosecutorial discretion for removal proceedings are not being considered anymore. There have been instances where rarely maybe they might consider it, but I know it's off the table. This is not something that Department of Homeland Security is really considering. Under the Biden administration, a lot of people were vouching for the prosecutorial discretion matters. It's called PD, where they were able to successfully have their cases dismissed or put on administrative closure. So, prosecutorial discretion is something that's not on the table anymore, or it's going to be very rare where they might be provided. The most scariest update is if you are someone who has a denied I-751, which is a removal of conditions application, or an adjustment of status, which is the I-485, and perhaps an N400, which is the citizenship application. Those denials may lead to USCIS issuing you a notice to appear, which is also called an NTA, where now you will have to go to the immigration court to fight your case before an immigration judge. So make sure if you do receive that notice to appear, schedule a consultation with an attorney if you don't have one to see what relief you might be able to file before the court, and do show up to your hearings, because if you don't, you may get an order of removal in absentia. So be aware that notice to appears after denials on those applications may be possible. Recently, another update had come out, and we actually got this from the American Immigration Lawyers Association, where now Department of Homeland Security is planning on to recalendar administratively closed cases before the immigration courts. I would advise everyone who has an alien number and your cases are administratively closed to keep checking your cases on a weekly basis by entering your alien number on the website, the EOIR website, or calling the 800 number to check to see if your case has now been placed back on the active docket. This is very important because failure to show up may lead to removal proceedings where now you're going to get an order of deportation in absentia, and that's just going to be a big issue to deal with. So pay attention, check to see if your administrative closed cases are back up on the active docket. If you have attorneys and they've been monitoring your cases, they might just be able to share that information for you. But if you don't have an attorney, definitely, do the due diligence by checking your alien numbers to see if your case went back on the active docket, and then have a strategy in place for that. So a lot of attorneys have been reporting that they're not being provided deferred action for their clients who have now received an approved special immigrant juvenile status. So generally what happens is if you have children who are minors under the age of 21 in some states, where they apply for special immigrant juvenile status. First, they deal with the state court, and then eventually the case gets filed with USCIS. And if USCIS was approving them in the past, they were issuing deferred action. So deferred action is a fancy word for trying to give you temporary relief for not throwing you into deportation proceedings. And it kind of protects you from that, where the child may wait for an immigrant visa to become available in order to adjust at a later time. So a lot of attorneys have been reporting that deferred action is not being given, and it just throws everybody off, because usually the practice was you apply for the I-360 special immigrant juvenile matter and get an approval, and there is language in that approval that says, oh, you've been given deferred action, where that child can now go ahead and apply for a work permit and work and go to school and do whatever they have to do without worrying about going into removal proceedings or have that fear of being deported. So another thing I want to mention is that it is very crucial that when you apply for adjustment of status or some type of case before USCIS, that you do the complete filing, because there have been a lot of reports of requests for evidence, notice of intent to deny. Some of them are based on the testimony that the applicant is providing at the interview, and some individuals are just getting a straight denial. So be aware, if you do receive a request for evidence or a notice of intent to deny, please make sure you plan it out where you have an experienced immigration attorney you're consulting with. If you decide to hire one, great, hire them on time in order to address those documents and respond to them timely. So make sure that the response is over to USCIS before the deadline, so you don't run into any issues of being denied. And some cases, some people are getting straight denials without even being offered a chance to respond on an RFE. If that happens, you may want to contact an experienced immigration attorney to see whether you can appeal that decision, or if it's wise for you to just refile the whole case. And that requires more filing fees. So, just pay attention. Best to not just do bare minimum and file like bare bones applications. Those are being frowned upon. Definitely work with somebody if you're confused about the process. That is highly, highly recommended. Okay, and the last thing I want to mention is that I've been getting a lot of calls, like lots of calls and messages about the people getting their N400s denied. And some of the reasons for these N400s are either they're not able to establish good moral character, or there's an issue with physical presence and or continuous residence issues. And a lot of times this is happening where, people were outside of the country because of COVID-related issues, and they're not able to explain why they weren't able to get back to the United States on time. What was the purpose of that travel? So those individuals ultimately applied for citizenship because those 5 years have now come up, and they're surprised, like, wait a second, now I have to prove all this stuff and I'm not able to do it. So what ends up happening is USCIS issues them a notice of intent to deny or a request for evidence to see if there is a way for them to prove that they do qualify for citizenship. But I've seen that some individuals are either replying to the request for evidence not on a timely manner, or they're not producing the documents or the information that USCIS is asking of them, and that's leading to a denial. And then the question comes up, well, they told me that I can apply for an N336, but remember, that always ends up being the case where you have to evaluate your case and see if you even qualify for that appeal, because you'll have to challenge the grounds of why your N400 was denied. And if you don't qualify for the N336, then you'll have to wait it out and see when you can refile for citizenship, which is refiling the N400, or just sitting and just waiting to not do anything, and then maybe you'll be able to hold on to your green card if you don't get a notice to appear in court. It's very complicated, but I have seen a huge pattern. This is my personal experience of individuals who have filed their cases pro se, so they represented themselves, end up facing a lot of issues at the interview stage or at the RFE stage, and they're coming to me at the denial stage saying, what do I do? And that's where we have to evaluate each case to make sure the right guidance is provided. So be conscious of, what you're filing, how you're doing it, have a strategy in mind. If, God forbid, something happens where it doesn't lead to an approval, but it leads to a denial, or it's a more lengthy procedure where now you have to provide USCIS or immigration court a lot more evidence to prove your case, work with an experienced immigration attorney. It is not wise to handle this yourself because U.S. immigration law can be confusing. It's not easy to navigate. And right now with the Trump administration, things are a lot more aggressive and things are a lot more different than they were the last 4 years under the Biden administration. So thank you so much for watching. I hope that today's updates were helpful. This is what's been going on for the past 5 months. If you know someone that is experiencing any of these issues or is in the middle of filing paperwork that they're not sure about, definitely have them check out my video. This is for informational purposes only. If you would like to use the comment section below to share some experiences or thoughts related to these updates or other matters, please do so. But if it's particular to your case, please do not share that information. That information is confidential and should always remain confidential. So I just want to say thank you so much for watching. And if you have not subscribed yet, please hit that subscribe button. It's really, really important that you do so then you can continue to watch me and get updates on anything I post on U.S. immigration law. Trust me, it's been a wild roller coaster for all of us immigration attorneys, but that will not stop us from getting you the information that you need to know, because some of this information is not made public. It's actually internal. And, I do have a lot of colleagues and wonderful, wonderful attorneys that I speak to that share experiences, and, I like to do the same back. So please stay tuned, come back, watch for more updates, and thank you so much if you've been supporting from day one. I really, really appreciate it.